Hello, everyone, and welcome to today's program, International Child Abduction under the Hague Convention, Legal Framework and Return Proceedings. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association. This program today is presented by our Family Law section, which is sponsored by White, Zuckerman, Warsowski, Luna Hunt, LLP, and SoberLink. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. You can contact them at wzwlh.com. SoberLink provides objective real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. You can learn more at soberlink.com. And now I am delighted to introduce our speakers for the day, Jeremy Morley, Anthony Storm, and the Honorable Scott M. Gordon. Jeremy Morley is an internationally recognized family law attorney focusing his practice on international family law from his New York-based firm with a global network of counsel. He is the author of International Family Practice, the leading U.S. treatise in the field, and the Hague Abduction Convention, Practical Issues and Procedures for Family Lawyers. A former co-chair of the ABA International Family Law Committee and a member of the International Academy of Matrimonial Lawyers, Mr. Morley frequently lectures and serves as an expert witness and provides media commentary on international child abduction and related issues. The Honorable Scott M. Gordon is a mediator, arbitrator, and judge pro tem with signature resolution, bringing more than 17 years of service on the Los Angeles Superior Court, including 9 years in leadership roles as an assistant supervising and supervising judge of the family law and criminal divisions. During his judicial tenure, he handled thousands of matters, including complex, high-profile international child custody cases, and was appointed by the Chief Justice of California to serve on the Judicial Council of California and to provide technical assistance on Hague Convention child abduction matters. And last but certainly not least is Anthony Storm, our president of the Beverly Hills Bar Association and founding partner at Storm Palyan LLP. He is known for his expertise overseeing electronic security issues related to divorce in for public figures. This includes taking steps to prevent disclosure of private information and minimizing the harm if disclosure occurs. Mr. Storm entered the family law arena following tenure as a clerk for the United States Attorney's Office, where he litigated criminal matters for the federal government. Recognized for outstanding service, Mr. Storm received an award from both the U.S. Attorney and from the Los Angeles County District Attorney's Office. We can't wait to hear what they have to share with us today, so I'm going to turn it over to them now.
Thank you so much, Ala. I apologize in advance. I have lost my voice, but I will do my best. Special thanks BHB has provided me with ginger, manuka honey, and lemon that I'm going to be sipping in hopes that I can make this happen for the next hour. We're so lucky to have with us two of the nation's leading experts on Hague abduction cases. As Ala mentioned, Jeremy has literally written the go-to guide. Judge Gordon has presided over so many of these Hague cases. He's an expert in the field. They are both my go-to resources whenever I have a Hague issue in a case or a risk of a wrongful retention case. And I'm very, very fortunate. I feel very fortunate that both of them agreed to do this presentation today. I think that everybody's going to find it very informative. I know we've been working hard on the presentation and I have found it informative. I'm constantly learning from these two experts and very, very proud to have them here today. So with that intro, I think I'm going to kick this off to Jeremy to give us an overview on what the Hague Convention is and what it does. Jeremy.
Great. Thank you, Tony. So the Hague Convention is a very interesting treaty. It's quite short. It is the most heavily litigated family law treaty in the world. It has spawned gigantic amounts of litigation. It is intended to deter international child abduction by securing the expeditious return to the country of a child's habitual residence of a child who's been taken away from the country of habitual residence without the consent of somebody who has a right of custody in respect of the child, or a child who's been kept retained away from the habitual residence when that child should have been returned to the country of habitual residence. It is intended to work expeditiously. It applies only between contracting parties. There are 103 countries or divisions of countries that have become parties to the Hague Convention. Only 88 of those countries have been accepted by the United States as treaty partners. So our State Department has the duty, through its Office of Children's Issues, of evaluating whether a new country that has signed the treaty has set up a system in its country to implement the treaty appropriately, expeditiously, appropriately, correctly, and has those procedures in place. For example, we have not accepted Russia as a treaty partner for reasons that you can imagine. Not every, yes, Tony.
No, go ahead, Jeremy. I heard a pause and I thought that maybe you were.
You open your mouth and
Yeah.
okay. So there are many very important countries that are not Hague countries. So just by way of example, India purposefully decided that it would refuse to adopt the Hague Convention. China has not accepted the Hague Convention, although Hong Kong and Macau are both parties to it. And so with respect to abductions concerning those countries, be careful because the normal Hague rules do not apply in those cases.
So, Judge
The
Gordon.
only, just very quick to keep us going, is a wonderful explanation, and thank you for having us. It is truly a living document, and as Jeremy talked about, the State Department is working with countries all the time that are changing their policies, emerging, and the document itself is alive. Just about a year ago, I was part of the U.S. delegation in The Hague. We literally went through for suggestions, wording changes and the like. So it is very much a living document. We'll move to the next one.
And we have, I was going to talk to you in particular about the justice partners. You having been earlier in your career a member of the DA's office, you might have some particular insights on how it's handled in California.
It really is a operational litigation where there are different justice partners. As Jeremy said, the Department of State is a key and primary partner there that's called the Central Authority. Also out of the U.S. Department of State, there is within the Hague Convention, there's an international network of Hague judges. Each country we have 3 in the United States. I have the honor of being one of the 3. And by being a member, we provide technical assistance to other countries, to judges here, and the State Department. In California, we are very lucky. The California Attorney General's office acts as our central authority for the state and have some really distinguished experts working on this. District Attorney's office.
Judge Gordon, we're cutting out for a little bit.
I'm sorry. Does that work?
I lost you at District Attorney's office.
Okay, so I just started in District Attorney's office have responsibility. In Los Angeles County, there is actually a child abduction unit that works not only on domestic issues interstate, but also will represent in the Hague hearings, which in LA are all in Department 2, will represent the state, the central authority, kind of as a neutral party. And then in the federal courts, and we're going to talk about whether these should be brought in federal or state court in a minute. Also, within many agencies, the law enforcement offices, federal courts, some of the marshal's offices provide assistance, and law enforcement agencies.
And that's something we'll get to in a little bit. California has some unique things with The Hague that are different from most states. With the DA, it's not something you find in other states. We'll sort of signposting, we'll get to that in a little bit, but I wanted to just inquire a little bit with Jeremy. As we're going through the basics of The Hague, can you explain the 2 basic types of Hague cases that are seen?
Well, the primary case is a case for the return of the child to the country of habitual residence. And I think we do that on the next slide. And so a return case happens when a child has been either wrongfully removed from the country of habitual residence or has been wrongfully retained away from the country of habitual residence. And if that is in breach of the petitioning parent's custody rights, then it is normally a wrongful removal or wrongful retention. The remedy in a return case is quite simple. The child must go back. The child needs to go back home. It needs to be done expeditiously. And that is the method that the community of nations adopted a long time ago as a means of not only returning abducted kids, but deterring parents from contemplating taking their child away from one country to another without the consent of the other parent or without a court order. The Hague Convention also contains one provision, Article 21, about access cases. This means primarily we're referring now to visitation rights being frustrated. The convention requires contracting states to ensure that these access rights are respected. And the remedy is to facilitate contact, not to physically return the child to the country of habitual residence. I need to say that for most of the world, the access provision set forth in Article 21 of the Convention is not anywhere near as important as the primary concern of a Hague Convention case, which is return. But it's useful to know and to understand that you can seek help, especially administrative help, in terms of trying to get visitation with a child who is overseas.
There are intricacies involved with the access cases as well. For example, we'll hit this in a little bit. I'm just signposting ahead. How does one, from a judge's perspective, there's a return and there's an issue of domestic violence. Can you remediate that with, say, a supervised visit? We don't know how other jurisdictions are going to see that. That's something important that we will hit on later on when we talk more about these access issues and return issues. But for now, I wanted to talk to Judge Gordon a little bit about how you even commence a Hague case.
Absolutely. Well, there's one thing I want to comment here on that last note about not determining the custody merits. When I teach this, I always say what we're picking out is a stadium where the game's going to be played, not calling balls and strikes or fouls, red cards and yellow cards. However, in one of the biggest challenges as we work with other countries and other judiciaries is in many countries there is a desire, a policy, what do you say, to determine best interest essentially visitation within this, which really we shouldn't be doing in Hague, but that is a tension. So with regard to starting this, and I think that the last box is important to read first and last. You submit an application to the central authority, a great website, you can go on. There's also on that central authority website a place where attorneys can volunteer to assist on these cases pro bono. It's a great program. Once that application is made and you have to attach the appropriate evidence and supporting documentation with declarations, and we're going to talk about proof of habitual residence. We're going to talk about that in detail. But that doesn't start the case. That's the application. They will issue letters and other issues, but a petition must be filed in the appropriate court, federal or state. And we're going to talk about some of the decisions that lawyers make, whether they want to go federal, state as we go forward.
And so I will always include in my initial Hague application for the return of a child, I will always include voluminous evidence, because the evidence that is attached to the Hague case, A, will be read by the judge up front, and B, is much easier to get into evidence. It's almost automatically in evidence if it's part of the Hague Convention application. So I get the ability to throw the kitchen sink in there, and I believe that the Hague application should be drafted with extreme care, extreme caution, even though at first blush it looks as if it's very simple.
So how do you pick where you're going to file, Jeremy? You can file in state or federal. We know we all learned in law school about the supremacy clause. We also learned as family law attorneys you have the UCCJA. We know about concurrent jurisdiction. How do you choose and how do you keep it in the form that you want it in?
So I would normally go federal court if I'm the petitioner. I may remove the case if it's brought in state court and I'm the respondent. I have to decide whether I think I've got more chance of success in state or federal. As the petitioner, I don't want to have the case in state court usually because of a reason that the judge just stated before, which is a Hague case is not a custody case. It is absolutely prohibited to treat a Hague Convention hearing as a custody hearing. A Hague case is not a best interest case. So I'm always faced with the issue, if I bring it in state court and family court, for example, before a judge who is trained in best interests and the supremacy of a best interest approach, I'm always concerned that such a judge might be tempted to veer into considering the case from a best interest analysis rather than apply the particular text of the treaty. Now, it may very well be that California is different for the reason that the judge has already mentioned, which is that you get to go, if you want to, you can go through the district attorney's office and they can provide tremendous assistance and they will, as I understand it, usually bring the case in state court. If you want to remove it to federal court, you don't have that kind of assistance. But in the rest of America, I will invariably have the petitioner file in federal court and ask the federal judge to do something that's very unusual, which is actually to deal with matters concerning families. So they're usually intriguing cases to a federal judge, and that we want the federal court to act quickly and not to consider best interests. And so I usually find that federal court works better for me. And most practitioners that I work with follow that same idea. And there's a simple procedure that we're 28 USC 1446 to remove a case that's filed in state court if you wanted to, but you need to do it promptly within 30 days.
So I'm going to do a little East Coast, West Coast thing here. I agree and I respectfully disagree. Being on the network, I get the wonderful opportunity to talk to U.S. judges all over the country. A lot of it, I think, depends on the jurisdiction where you are. There are certain jurisdictions, Florida, Texas, California, New York, where there are a lot of Hague cases, and I'm going to agree with Jeremy, the fellow judges there have experience. I talk to judges from all over the country, and many times it's what's the Hague? You know, a great city in Holland, Den Haag, but it's what's the Hague? Other family law judges have done them. I really think you need to do some research. In California, and especially Los Angeles County, I do think it's different. One, we've got the California Department of Justice, which provides tremendous assistance. We have the district attorneys who provide tremendous assistance. And in LA, all of these by policy decisions go to one place. They go to Department 2, now with Shelley Kaufman, who's done many of these, is fabulous judge, as you all know. So you have someone that has tremendous experience. So I agree with Jerry, but I would do some looking to see what's the experience in that particular area, where they're done, and who has the information.
Yep.
I have a question on that. So in California, here, Judge Gordon, say hypothetically, district attorney is assigned, they're prosecuting it, and Jeremy's on the other side, he wants it in federal court, and he tries to pull it out and have it removed to federal court. At that point, do you lose the district attorney, or is the district attorney actually appearing in federal court on these DA cases? I mean, on these.
Normally it's state, but I think they will. It depends what their policy is now, but normally they're state. But I think they will assist.
Interesting, because
But normally it's state,
Yeah.
but by 99%, it's state.
Yeah.
They come over to Department 2.
Okay. Well, then, in talking about whether you're going with in federal with the Hague Convention or the UCCJEA, we've talked a little bit about, Jeremy brought up where to file. I know in California, yeah, you sort of, well, not in actually everywhere, because sorry, my bias is California, because I always think California, but UCCJA is pretty much everywhere.
Yes.
So how are you really deciding? Our next slide is a critical comparison before the case is commenced. And
So, yeah.
I think, I thought this was, oh, go ahead, Jeremy, I apologize.
So you've got a choice. In fact, you can have two bites of the apple. you have to determine whether, as the practitioner, you want to start a Hague case or you want to start a UCC-JEA registration case. By UCC-JEA, I mean the system whereby if there is a foreign court order that's been issued or could quickly be issued by the foreign court, if that foreign court is the home state, so that under UCC-JEA, the foreign court has child custody jurisdiction as we in California or elsewhere in the United States would consider appropriate jurisdiction. If I have a custody order that's favorable or can get a custody order that's favorable, do I want to go that route and register, or do I want to instead go Hague Convention and proceed that way? The reason that the professor who basically wrote the UCC-JEA has written an article explaining why the UCC-JEA might often be preferable is that there are only two defenses in a UCC registration case to register and enforce, which are, did the foreign court have jurisdiction, and did the foreign court provide notice to the respondent? There are 6 affirmative defenses to any Hague Convention case, which we will go through. And so if I'm worried, for example, that the other side is going to claim grave risk of harm as a defense because there's been claims of domestic violence, then I might well be better off not using Hague, but going through the state court and seeking registration. This is a critical decision that you have to make. I do have a case now where a Hague case was brought, and the Hague case was the return to the foreign country was denied by the federal court. We are now seeking to register the foreign court order in the state court in New York. Even though the federal court has denied return, we say that we are entitled to the second of the 2 bites of the apple, and I think that we're taking the right approach in that regard.
So Judge Gordon, courts are overworked, they're impacted. There's a timeliness issue with these Hague cases. And Susan, we're moving on to the next slide about the hearing. How do you ensure you can really have a timely and expeditious Hague case in state court?
This is a great question and a great issue. And I will tell you, in talking to other judiciaries from other countries, this is probably the biggest issue. In fact, I was just at a conference in Brazil about 6 months ago, and this was a huge issue where they were going to make a commitment to try to adhere to this. And a lot of especially Central American and South American countries, it's a real challenge. The convention notes all through, and specifically, these are kind of emergent hearings. It's about returning a child to their country of habitual residence. Article 11 says it should be expeditious, and there is a 6-week recommendation. It is not a 6-week or dismiss like the time limits we have in a criminal court, but there is a recommendation. I will tell you, when I do these cases, that is real important to me, and I try to adhere it. You hear the word try. We're going to talk in a second. Jeremy's in a second going to talk about discovery. Those become issues. Availability of counsel, practical. There are practical issues, but you really should for the 6-week target. If you're working with a court in another country, be sure to check their appellate policies, because in many countries, every single decision, every single thing that occurs can be appealed and delay it tremendously. So it's something you have to really be concerned about. Most judges, the federal judges I've talked to, try to adhere to the 6 weeks. I know we do here, but I want to emphasize try with a capital T.
So this is really a niche specialist area of family law. There are unique issues. For example, when you have these speedy trials, you have a right to discovery. But if there's a 6-week recommendation, you don't have the normal discovery rules to try to get everything done in 6 weeks. So Jeremy, as the litigator, I want to talk to you about how you ensure you get your discovery in, what's permitted, what is not permitted. How do you really strategically plan to get your case across the finish line quickly?
Do you want to get the case across the finish line quickly? That depends on which side you're on, I think. And in federal court, my cases are taking a year, which is an outrageous violation of the treaty. Our State Department is ordered by Congress to report on the compliance by other countries with the terms of the Hague Convention. And the usual complaint that our State Department makes is that the other countries are not acting fast enough. Why don't we look in the mirror and look at our own performance, which at least on the federal level is generally pretty terrible, starting with the US Supreme Court, which in its recent cases have taken 2 to 3 years before they finally make a decision. Anyway, with respect to discovery, you ask for it. Whether you will get it is discretionary with the court. There is no provision in the convention that authorizes discovery. There's no provision in the International Child Abduction and Remedies Act, which brings the convention into US law, that provides expressly for discovery. You ask the judge and you explain why it's needed. The judge will typically, at least federal court, will typically require you to expedite this and require you to meet a burden of establishing why in this case it really is necessary in these circumstances. The petitioner will, the respondent will usually ask for discovery. It can be about anything related to the expected defenses that we're going to be looking at soon. Most judges do allow some discovery in my experience, but they put you on a fast track usually. They should.
So, something you've said really is troubling a little bit. And I'm wondering how you deal with this. And Judge Gordon, you can opine too. Say you have a case that takes 3 years, like Jeremy's, and you have a 13-year-old child. When the child becomes 16, is your case become moot?
We're going to get to that in a second. There's a slide on identified a really big challenge. I don't want to be a spoiler here, but it's a big challenge.
I know I'm jumping ahead. It just when I heard
you could be up the proverbial creek there. This is a very interesting question on the evidence. I'm addressing from the convention and from a judge's point of view. The convention talks about flexible evidentiary standards because you're talking about all different countries, right? Different lawyers from different countries, rules coming in. I'm going to tell you that different countries conduct them differently. Here, the ones I've done, they're really kind of our typical adversarial. I was talking to a German judge a couple months ago, and there the judge does all the inquiry. Lawyers don't ask questions. The judges ask all the questions. So it depends where you are. There are flexible evidentiary standards. It's up to the judge. I think you lean toward letting things in, especially you're going to be dealing with foreign documents many times. The issue of foreign law is going to be an issue because, as we're going to see in a minute, you have to determine about custody rights. So how you get that law, whether it's through declarations, an expert, you have to be flexible. And the court has broad discretion, especially because of the time. And I agree with Jeremy. I think these cases really need to be on a fast track, and I cannot criticize one word he said with regard to that.
Well, as a judge, as a bench officer, how do you deal with, so say the evidence is in a different country and you have a lot of hearsay issues?
You do, and you have to be flexible about that. And I think it augurs to allowing relevant evidence in, and you have to be flexible. And hearsay, whether hearsay is even recognized in different countries and what is hearsay or not is completely different. Is the key here to me as a judge, leaning toward getting the appropriate and reasonable evidence that we need to get to make the appropriate determination.
All right. Well, Jeremy, how do you really establish a prima facie case for a return?
I'm talking now with my English accent. A prima facie case is for the petitioner to establish that the petitioner had a right of custody in respect of the child under the law of the country of the child's habitual residence as of the time that the wrongful removal or wrongful retention occurred. The burden is based on the preponderance of the evidence. And typically, that part of the prima facie case in many, many, many cases can be established very quickly. If they're married, they clearly have rights of custody under the foreign law. If the child was taken away without the permission of the left behind parent, there's clearly a wrongful removal unless there's some kind of court order or clear agreement to the contrary. And the remedy you're seeking is simply the immediate return of the child to the country of habitual residence. It's got nothing to do with best interests. The burden then shifts to the respondent to establish what are the affirmative defenses. Most of the affirmative defenses actually are discretionary. They're not really defenses. They are recommendations. They are exceptions. And the burden of proof is upon the respondent to establish one of those exceptions and to convince the judge in the case of ones that are discretionary that it would be appropriate. I'm not using the word best interest, but it would be appropriate to return the child even though one of the defenses has been established or not. That's a question for the court to decide. So there are different burdens of proof.
So Judge Gordon,
I was going to say, go ahead, Tony. I'm sorry.
no, you got this. I think you're
Okay.
anticipating what I'm going to ask. So go ahead.
As you go through this, and family law in general, it shift around to different sides. It's something we're used to as family lawyers. But here you have to be very mindful of who has the burden and what is the burden. And as Jeremy said, it changes. And the petitioner has that preponderance burden. We know we have a slide on this, but everybody kind of knows what that is. And that goes to those initial elements, and it's very elemental. Habitual residence, the breach of those rights, and the exercise. It then shifts the respondent. And these different defenses, just as Jeremy said, and we're going to talk about them in a minute, have different burdens of proof depending on the defense. The well-settled, consent, mature child are preponderance. The grave risk, which is where we get domestic violence 13B, and the human rights, fundamental freedoms are clear and convincing. Lawyers need to keep that in mind. Judges that are litigating these cases need to keep that in mind, especially when it comes to the different defenses.
And I think everybody here knows what the meaning of the next slide is. What's the difference between a preponderance of evidence and clear and convincing evidence? I think we've covered this next slide well enough. So let's move on to the 3 required elements that we need to prove: habitual residence, breach of custody rights, and the exercise of custody rights.
So we're going to be, I briefly mentioned each of these 3 elements. I think that the idea of them is pretty straightforward. Where was the habitual residence of the child at the time of the wrongful removal or retention? Was it in breach of custody rights? We'll discuss custody rights in a moment. And were those custody rights being exercised? To answer a question before about the age of the child must be under 16 years of age at the time the petition is filed. But the minute the child turns 16, even if it is in the middle of a Hague Convention case, even if the child has not been returned yet, the Hague Convention case automatically ends on the 16th birthday. There's no more case, which is another reason why a respondent wants to drag the case out sometimes, and a petitioner is very, very anxious that the case proceed expeditiously.
So what I'd like to do here, we're going to take a deep dive into all these elements, whether it's the habitual residence, wrongful removal or retention. Let's talk about a hypothetical and work our way through this hypo for the remainder of the presentation. So that hypo, you have a mom, she's a US citizen. You have a dad who's an Italian citizen. They were married here in Los Angeles, where they had a baby. And after they had this baby, they decided to go live in Italy for 2 years. A couple years go by. They love their Italian lifestyle. They've now been there for 5 years. Their child is 6 years old. Their baby speaks Italian. She attends school in Italy. Her doctors are in Italy. Her friends are in Italy. She has a network in Italy. Mom has family in LA. There's an alleged domestic violence incident with the mom. She tells the dad, I want to go for the summer, visit my parents, and bring our child with us. The dad says, sure, go to LA over summer break, take our child with you. She buys a round trip ticket for the summer, but she never returns. There's no order in Italy. Nobody's filed for immigration status for either her mom or the child. There's no Italian citizenship for them. Mom says, I'm not coming back. She misses her flight home. She enrolls their child in school in Los Angeles without dad's consent. So, given this hypothetical, I want to really start to dig into these factors, and maybe we can talk a little bit about what would be the habitual residence in this type of case. Who files? What if mom files first for custody in California and then dad files a Hague petition in federal court? Is there concurrent jurisdiction? What controls? Could it be removed under 1446? Let's start talking about all these different elements. And I'm going to start with Judge Gordon. If you can talk a little bit about the habitual residence factor, that would be terrific. Thank you.
And great hypo, it's kind of great law school. You kind of hit everything, but yes, absolutely. Habitual residence is probably the primary or most important things that occurs. It is contested. It is complex. I will tell you, it is very factually intensive. All those things that you talked about in your hypo, about school, language, friends, how long, jobs, where belongings are, have residence changed, what were the intent of the parents? All these factual things come into effect. It's going to be up for the court to decide, but it is a factual determination on totality, and the court needs to be mindful and really look at all of the facts that are appropriate to determine. It's not like the UCCJA where we have, X number of months and, kind of thing. This is a factual determination.
Why does it matter?
First element is huge. It's kind of it's the big, which jersey are we wearing kind of thing. It's the first element. It is going to govern us as we go through. And, Jeremy initially talked about the intent of the convention was to basically return children to their the proper country. That's that presumption. So it's really important.
So you're the bench officer, Judge Gordon. There's the Minoski case. What sort of circumstances are you looking at when you're analyzing where the child was the habitual residence?
And Minoski is a great case, a 2020 case, and it talks about, I'm going to look at everything. It's a totality of circumstances. I am going to look at everything that the parties present. How long have they been there? What were the circumstances of them going here or there? What was the circumstance of the residence? Was it purchased, rented? Was there communication between the parties about how long they stayed? What's the child's social kind of circle? What is education? What's the work of the parties? Are they employed there? Are they not? Are there judicial orders or interventions in either of the countries? I'm going to look at all of that.
And Jeremy, you're the attorney here. How are you arguing this? Which is the country of habitual residence to you? The kid was born in LA.
Country of habitual residence, to me, the way you drafted the hypothetical is clearly Italy. So
Okay.
I hate to say anything clearly in the context of a Hague Convention case, especially habitual residence, but the kid's been there since I think since he or she was a little baby, been there for 5 years. So if you were to look at the jurisprudence before 2020, you would see all kinds of conflicts about different presumptions. You would see thousands of appellate cases on what is the meaning of the term habitual residence. The Supreme Court in Manaski, Judge Ginsburg rendered a unanimous decision that the clear and specific test of habitual residence is the totality of the circumstances, whatever the heck that means. I mean, what that means is, as Judge Gordon said, you look at everything. But there is some teaching in Manaski that really helps. And that is fundamentally, as I read it, we're looking at the situation through the eyes of the child. And assuming the child is not a mere infant, where would the kid consider home to be? Where is the child's home looked at through the child's eyes? And since this child has been in Italy for a long time, speaks Italian, goes to school there, has doctors there, probably has friends there, and has had not many connections, I would suspect, with the United States, then I would say, even if there's going to be evidence that mom and dad agree that they're going to come back to America after a couple of years, I think that here you're going to look at the situation through the eyes of the child, and this child is home in Italy, the place where he's been living for the last several years. If we took the hypothetical and changed it so that the child had only been in Italy for 2 years, then you have a tricky question that maybe could go either way. And the job of the litigator is to round up every bit of evidence that you can to show, if you're representing the petitioning parent who wants a child back, then you round up every friend, every doctor, every school person to present evidence to support the idea that this child was at home in Italy. If you're on the other side, you're doing the opposite. You're showing how often the child came to the United States, how much time he spent with the grandparents, how young the child is. You build up the opposite case, and the judge makes a decision. The judge's decision, by the way, and this is critical, will not be overturned on appeal, except as long as the Manaski is cited. The Manaski decision states that there is the determination is, I'm trying to find the exact language of it, but it is if the law is correctly cited, that issue of is discretionary with the trial court. It's very, very, I've not seen any case since Manaski that has overturned a trial court's decision on habitual residence.
But I think it's my job really make my findings cite Manaski, but also talk about what are the things I've considered to get there.
Yep.
Right.
Exactly.
And I think findings are something that the court really needs to really make very clear. If you're an attorney litigating this and the judge doesn't make the specific findings you need, you ask. You ask for them and request that they make the findings that you need for the case.
Absolutely.
Moving on, I want to talk a little bit about wrongful removal and retention. I'm going to turn to you, Judge Gordon, to talk about what these things are. And then Jeremy, can you talk about the legal standard for them after we describe what they are? And in this hypo, if this in this hypo is a wrongful retention, did it occur when she missed her flight home? Did it occur when she enrolled the kids in school, or did it occur when she said, hey, I'm not coming back?
So you have to designate kind of which theory you're going under for return. I'm going to start with retention and go to removal. And you see both. Retention is kind of like your hypo, where I'm going to go home to visit the grandparents for a week and then I stay. I'm going to go on vacation and I stay. It's the leaving with an understanding of return. However you prove that, whatever evidence, like you put in here, round trip ticket, great fact. But you refuse to come back. Removal doesn't have those. Removal is just taking. Removal doesn't have those agree to go. It's parent A takes child to another country. They're both, again, factually determinative, but you have to designate which and then provide the appropriate evidence that supports it.
So as far as the legal standard, and I'm moving a little bit faster now, we have about 16 minutes left. So Jeremy, can you talk to us a little bit about, or talk to the audience about Article 3 and 5A?
Yeah, so Article 3 says that the removal or retention of a child is wrongful if it's in breach of custody rights attributed to a person or an institution or another entity, either jointly or alone, under the law of the country in which the child was habitually resident immediately before the removal or retention. So if you're analyzing a Hague case, the starting point actually is what is the relevant date? And then we have to look on that date, where was the child habitually resident? If, as the judge was indicating, if it's a removal of a child allegedly without consent, then the date is easy. The date is the date the child was taken away. It's much more difficult often when it's a wrongful retention. In your scenario, you very appropriately talked about the round trip ticket. So if the child is kept without consent after the date of the return on the round trip ticket, normally that is the relevant time. However, sometimes we have situations, as in the one in your example, in which the taking parent has done something perhaps quite silly, which was start a case for custody in the place that has no jurisdiction, which is California, which endorses or corroborates the fact that the taking parent is trying to select a better forum in direct violation of the principle underlying the Hague Convention. So there are recent cases which hold that an anticipatory breach of an obligation to return a child is also wrongful, and at the time of the statement by a parent that I'm not going back, even if before the date on the airline ticket, that could well be the relevant date. So then the petitioner has to establish that under the law of Italy, under your example, on the date that she started the case in California, what rights did she have under Italian law concerning custody? They're married, so presumably it's very easy. If they're not married, you get interesting questions, and you will need to have either expert evidence as to the Italian law concerning the rights of a parent, or you need to have the assistance of the Italian central authority, who is allowed under the convention to provide that input as to what Italian law provides as to whether or not the parent had a right of custody over the child on the day the child was removed or retained.
Well, I'll say thank goodness for remote hearings, because prior to having Zoom and here in Los Angeles with LA Court Connect, having these experts appear remotely from abroad must have been quite an undertaking. How does a parent exercise custodial rights at the time of the removal?
So I think Jeremy hit it right. You have to there's kind of two different scenarios you see. The more common one is when there's been no court intervention in the other country, say the Italian court here. They're married, they're living, the parents together. The other is where there may be a order from that other country. There could be a custody order out of a divorce, parentage action, DV action out of the other court. So at first you have to make that determination. Is there a court order? Second, there is what are that, exactly as Jeremy said, what are the custody rights, the inherent custody rights in that country? You have to be flexible in getting it. And then you have to look under that law, not here, not what we would think, unless it's, American case, but if it's the habitual residence is in Italy, what does that law say about a parent? How is a parent exercising custody? Normally it's factual. Are they seeing the child? Are they living together? What are they doing? And you have to analyze those facts according to the law of that country. It is very factually determinative.
And so if I may just chime in order to, you have to show that the petitioner had custodial rights.
Right.
If you're in a South American case, there have been many cases where, let's say, one parent has received an order giving that parent sole custody. However, under the law of Mexico, a father automatically has what they call patria potestas rights, which is inherent rights of a parent to supervise the life of a child. And there have been many decisions in the US that hold that even if a parent has sole custody from such a country, the patria potestas right under Mexican law, which has to be established by a Mexican law expert, provides the left behind parent with custody rights for the purposes of the Hague Convention, and therefore can pursue a Hague Convention case. The petitioner also has to establish that that parent was exercising the custodial rights. However, the law in the United States is that it's very easy to establish that the parent was exercising custodial rights. In fact, several cases have held that you need evidence of unequivocal abandonment of the custodial rights for the defense of non-exercise of those custodial rights to work. So it happens in very unusual cases only.
So moving quickly through the next slide, we know a child has to be 16 years old. Very quickly, let's change the fact pattern. Child is 15 years old, and you have this you're entitled to an expeditious hearing. We know these cases, they're supposed to take 6 weeks. Sometimes they take over a year. What happens?
Case is dead on well, the day of the child's birthday, no more case. Automatically, the court has no power to do anything else.
Judge Gordon, is there anything an attorney can do to red flag this issue to the court, saying, "Hey, our kid turned 16 in 8 months. I need this I need a trial date quickly."
Exactly that. Exactly what you've just said. Exactly. Just break, the court should know, but exactly. Absolutely.
So then let's move on quickly. I think this age eligibility requirement we've talked about, it's pretty straightforward. 16 and the case is done. Let's talk about affirmative defenses. So Judge Gordon, can you briefly talk to us a little bit about the types of affirmative defenses that you have in the case? Thank you.
Absolutely. Can we go to the next slide? I think so. And this is where really kind of a lot of the meat is now on what's going on. And you have the well-settled defense. If more than a year has passed since a wrongful removal, is the child well settled in the country? And again, factual. Can't be raised if the petition is filed within the year. Consent, like in your case, in the case we have in the hypo. Mom says, Dad said I could move. There's a consent there. The acquiescence, which is, I think, very, very similar, that the on a removal, the parent agreed to. 13B. 13B, I think, is the hottest thing in The Hague. There was just a huge conference in La Fortaleza, Brazil on this. This is if the return would place the child in a grave risk of psychological or physical harm, and it's clear and convincing evidence. This is where DV comes in. And I'm going to tell you that different countries, how they look at this, what's the level of DV is broad and sweeping in different countries, but that's DV. Mature child's objection, it's kind of like our 3042. It's something you take into account. If a mature child, what that means, you have to, again, factual. And then human rights, if there's something going on in that country, a war, oppression of a certain group, whatever it is, that would expose that child to harm because of basic human rights and fundamental freedoms. It is not usually as successfully invoked. It's clear and convincing evidence. I've seen a couple in places where there's war and unrest. I'm going to say I think 13B and domestic violence is where the real issues are now.
And we'll hit that. We'll spend a few minutes on that in a minute. What I wanted you to also chat about, Judge Gordon, if you have a minute, is when the standard of proof, the burden of proof, is a preponderance of evidence versus when it's clear and convincing.
Great question. It's on the defense that the respondent is bringing. So well settled, consent or acquiescence, mature child is all preponderance. When we're talking about grave risk and the human rights and fundamental freedoms, it's clear and convincing. So it's respondent and depending on the defense raised.
So changing our hypo, we're no longer in Italy, we're in the Sudan, for example. And somebody's making a grave risk defense saying, there's risk to mom, risk to the child who's female upon return. Jeremy, how do you argue legal standard? How do you prove your 13B case if you need to? What qualifies? Is it the risk evaluated by the Sudan, or is it evaluated here in the United States?
It's evaluated by the court in which the Hague Convention case is pending, which in your hypothetical would be the court in California or elsewhere in the United States. The judge in that case has to make a determination as to whether, if the child is returned, the child will be at grave risk of harm or being put into an intolerable situation. There is substantial authority that the defense should be, or exception should be, interpreted narrowly. Otherwise, the Hague Convention would have little or no meaning. that is a reason that's often cited as to the narrow interpretation that's required. It's as the judge just indicated, grave risk is the critical issue in so many cases, partly because it's the exception that has the most ambiguous terminology. So you can always claim there be a risk. You can, and then if you're representing the petition, the respondent, you always can claim that it's grave. So you need to support that proposition by evidence that bad things have happened, or bad things have been threatened, or bad things are likely to happen if the child is returned. I don't think you can guess that just because the country is, a country that doesn't have such a great legal system, that necessarily terrible things will happen. You have to prove that there is a grave and significant risk of danger to the child, which sometimes can be because of danger to the parent, the primary caregiving parent, to a certain extent. But you have to interpret it narrowly, and you need to support it by clear proof, both normally in the form of evidence by the respondent, the taking parent, that he or she has been in danger, has experienced terrible circumstances, and it is likely that those circumstances will continue. If you're representing the respondent, you often will bring in expert evidence, psychiatrists, psychological support, to say that I've tested the child is at grave risk of, the child is suffering from PTSD as a result of something or another. In some cases, we are able to get the psychiatrist to state, in my opinion, if the child is returned to that country where the PTSD facts occurred, then there will be an immediate recurrence of the problems that the child is clearly suffering from. So you try and line up your expert evidence, and you try and present as strong a case as you can to support the serious claims that you're making.
From the judge's perspective, you're dealing with so many different subjective facts based on different international standards. There are preventative measures that could be taken. I want to talk a little bit about that, but how do you really deal as a bench officer, deal with what might be normal in one culture and versus what is acceptable here in your courtroom?
I think that if you're a judge doing a Hague cases, one of the things that you really have to be mindful of is not become kind of let your biases about other countries. Every country thinks their system is the best. There are Central American countries think that DV is so bad in California that it's presumptively grave risk to come back to California. You have to not be paternal, maternal about the other country and respect the sovereignty of those courts. I think that's a very important thing to do. And you need to listen to the evidence, not base it on your feelings, but the evidence that these wonderful lawyers have presented.
Okay, thank you, Judge Gordon. That's very insightful. There are so many other critical issues in Hague cases that we haven't gotten. I'd like to also talk briefly about some practice pointers, what litigants can do in our last minute here, what litigants should be doing. Disposition of passports, undertakings. How does the United States deal with findings and international recognition? Jeremy, can you close us out quickly and give us a few good practice tips?
One thing that I'm always concerned about is that the taking parent who's run away from the country of habitual residence might do a do-over, might go somewhere else. So the first time I'm before the court, I'm asking the court to issue a temporary interim order, which the court is authorized to do, to require the respondent to appear in court with the child, to deposit all passports and other travel documents with the court or with his or her counsel or the other party's counsel, and to order that there shall be no removal of the child from the United States. As you know, the United States does not have any exit controls. In any case like this, and in any case where we're trying to prevent any kind of an abduction, it is incumbent upon us to understand that we can, if we have a court order, ask the State Department to put the details of the child on the non-removal roster that is maintained by the State Department with Department of Homeland Security. But I need an order from a court in order to do that. Otherwise, anybody can leave this country with a passport from somewhere or another that you can buy from some Caribbean country, perhaps, and then go to a third country. So I need to rush into court the minute I'm filing the Hague petition to get appropriate input from the court to provide immediate protection, and also to order that the other parent perhaps shall stay away. I may need an interim stay away order, for example.
And perhaps maybe notify the embassies so they just can't get a new passport reissued.
With respect, Tony, that's very logical, but it doesn't work. So the other country may or may not choose to listen to what our courts request.
And Judge Gordon, any other final thoughts, practice pointers that you'd recommend for practitioners?
I think everything Jeremy raised is outstanding. I think the DA's office here comes into great use, and I will make specific orders about visitation, about where the child resides before the hearing, about as indicated documents. All of those things you have to be practical.
We're out of time, but I'll add to that. Make sure you ask for the findings you need. I'd like to thank Mr. Jeremy Morley and Judge Gordon for what I think was a really insightful, valuable panel. I learned a lot from both of them, and I always will. I mean, they're great resources for me personally in these areas, and I think we're lucky to have them both here today. So thank you both for this and handling it. And if anybody has any questions, they can always send me an email and I'll do my best to answer them. Thank you.
Thank you, everybody.
Thank you.
Thank you.
Thank you, Tony.
Be well.